Well, first, let me begin where I started off. Thank you, Mr. Chairman, for holding this hearing. And I want to thank you and the witnesses for the demeanor of the hearing and the manner in which we're looking at issues, because the issues you raised in your questions, I'll have some of my own to raise, are exactly what I hear from other members. It's really not a partisan issue. It becomes an institutional issue. And so this is extraordinarily helpful in discussing, the institutional matters in front of us, and also, indirectly looking at the merits of the claim. And let me say, I agree with the chairman. Each one of these should consider separately. They're not linked together in any way. Each document we should look at, each decision we should make individually. And the fact that others have a claim should not affect the claim that the Cherokee Nation is advancing. I very much agree with that. Chief Hoskins, I would like to ask you in a more practical way, actually, how do you view the role of the delegate to Congress? Would he or she, and in this case I think we could say she, Kim is a very good friend of mine and somebody I respect greatly, how would that member be treated in the same manner as other delegates that we currently have? Or would he or she have different duties, rights, and responsibilities than like the delegate from Puerto Rico and Guam and Samoa?
Well, Congressman, thank you for the question. I think they would be similarly situated to the delegates that serve alongside you today. So the opportunity to serve on committee, have committee assignments, vote on committee, propose legislation, debate, all the way to the House floor, of course, not voting on final passage. Otherwise, I think it's the entire depth and breadth of the delegates that serve in this body today.
So I think that's really important for other members to understand. We're not talking about anything different here than we already do in multiple cases. In this regard, in terms of how that delegate would act and the authority and responsibilities they would have as a member of Congress. Second, and I get this question a lot, so I want to pose it to you. Obviously, this is an old treaty right, 1835. Why was it not addressed or impressed immediately? And I would also take that on advisement. I mean, I'm glad to hear your answer, but if you have additional information later from historians or whomever, I mean, that's a question I get. Well, gosh, if this was there and it was a treaty, why wasn't it done immediately at the time? Why didn't the Cherokee Nation, and maybe it did, advance the claim at the time?
Well, Congressman, I love this question because it gives me an opportunity to talk about Cherokee history, of which there's not enough knowledge in this country.
That's why I opened the door.
You certainly possess it, but I won't miss the opportunity. The history since 1835 with the Cherokee Nation has been one of rebuilding and then being suppressed again, being oppressed again, being dispossessed. Seem to be in rebuilding modes through the last 2 centuries. Think about what happened. The Trail of Tears came after the Treaty of New Echota, nearly destroyed the Cherokee Nation, lost a quarter of our population, ripped apart our institutions, was the near destruction of the Cherokee Nation. We rebuilt. That story, Mr. Chairman, ought to be an entire story that every American understands, because our rebuilding is incredible. But it took a great deal of resources. So when we get to our new homeland and what would later become Oklahoma, we are simply trying to survive and rebuild a great society. Decades go by, the Civil War visits the Cherokee Nation and brings even more destruction and division than the Trail of Tears, if you can imagine that. We go into another period of rebuilding in the post-Civil War era, late in the 19th century. At the turn of the 20th century, as we know, the state of Oklahoma is created by the Congress of the United States. A number of federal Indian laws are passed, which again dispossess Cherokee people of our collective possessions, our lands, nearly dispossesses us of our government. I think, Congressman, a lot about my grandfather in this role. Let's get into the 20th century. My grandfather's century, a full-blood Cherokee World War II veteran. The United States suppressed the democracy of the Cherokee Nation to such a degree that he could not vote for a chief of the Cherokee Nation during most of his lifetime. I don't imagine he ever thought his grandson would be the elected chief of the Cherokee Nation. But in the 1970s, we start to rebuild, and we've been on a trajectory, as has other tribes in Oklahoma and across this country, of building economic strength, prosperity back home. And so we are now, I think, in a position where we can, as a practical matter, assert this right, whereas my predecessors in the 2 centuries before, frankly, we were just trying to hang on to our way of life and rebuild. So that's the explanation.
Well, just to offer a personal comment and support, I know exactly what you're talking about. My great-grandfather was treasurer of the Chickasaw Nation at that very same time. And he had to sit there in our Capitol on the 2nd floor and figure out how to dispose of our property which was taken from us inappropriately, both in terms of individual plots and then, frankly, what we gave back to the United States government to try and protect, like what's the heart of now the Chickasaw National Recreational Area, was literally sacred springs to us, and we didn't want them in private hands, so we literally gave it back to the federal government so it would be, it's now the core of a national park. But believe me, I understand the difficult decisions that your forebear made. Ms. Schwartz, I want to ask you, and I invite the other panelists to also weigh in on this, your thoughts as to whether the Treaty of New Echota is still in force, and to explain whether you believe the Cherokee Nation is a successor in interest to the treaty, or whether that's still an open question, because obviously we have some issues raised by others about that.
If I can briefly address the latter part of your question first. The Congressional Research Service does not take a position on whether the Cherokee Nation or other tribes are successors in interest to the Cherokee tribe that signed the treaty. We are participating in this hearing essentially on the understanding that the Cherokee Nation is a successor in interest, and there has been case law determining that the Cherokee Nation is a successor in interest to the historic Cherokee tribe, particularly in the context of the 1866 treaty, which did reaffirm the previous treaties, including the Treaty of New Echota. But we do not take a position on whether other Cherokee tribes of today are also successors in interest at this point.
Thank you very much. It's very good. I'd invite Chief Hoskins and then Professor Robertson to answer the same question.
Well, Representatives, I do have an opinion on this.
I suspected you might.
And I think plainly the historic record and the law demonstrates that the Cherokee Nation, of which I've got the honor of being the elected principal chief today, is the Cherokee Nation, the same Cherokee Nation that is party to every treaty with this country since its founding and that predated this country. I have great respect for the two other Cherokee bands that have been mentioned, the Eastern Band of Cherokee Indians in North Carolina and the United Ketua Band of Cherokee Indians in Oklahoma. The issue with the Eastern Band was disposed of by the United States Supreme Court in a decision in which they determined that they were not the successor in interest. That question's been asked and answered. The United Ketua Band of Cherokee Indians in Oklahoma was authorized by this Congress in 1946 and recognized in 1950, more than a century after the Treaty of 1835, certainly, and well after the last treaty that this nation, the Cherokee Nation, signed with this country in 1866. The Cherokee Nation, of which I have the honor of being the chief, is the same Cherokee Nation that signed those treaties.
Professor Robertson?
Yeah, I'm not sure I have much to add to what's been said by my co-panelists. I do understand that the Interior Department is looking into some of the questions that you raised, Congressman Cole, and I believe that process is ongoing, so it may be that there are answers coming from Interior.
Okay. Professor Robertson, let me ask you this question. Both the Constitution, Supreme Court precedent have highlighted the equality principle, the idea that one person's vote is equal to another person's. With the potential of appointing a delegate who would already have congressional representation, would you have any concerns about the constitutionality of the delegate? And I would invite others to respond as well.
Yeah, I think the argument that I find persuasive is the distinction between that's been raised in some of the materials presented, is the distinction between a member/representative and a delegate. The power of delegates is, well, there may be some practical advantages to a represented constituency to having a delegate in terms of opportunities on committees. The denial of the power to vote for final passage of legislation, I think, is a severe limitation. And I think the Constitution uses the phrases member and representative deliberately to assure, and the constitutional law cases relate to those positions because they have a final say over the laws that govern the land. And there, I think the equal protection concern is most severe. So, without having dived into the issue in depth, my initial thought is that that distinction is material. And so I don't know that I would have any particular concerns.
Okay, I'll turn to you, Ms. Schwartz, and then Chief Hoskins. I'd love to get your opinion as well.
So the instruction that we have from the courts is not directly applicable to this case. We do have determinations about the constitutionality of the current delegates, the territorial delegates, but there is a distinction in that none of the territorial delegates represent citizens or residents who already have representation in the House. So the particular situation that we're facing here is not one that the courts have weighed in on. That said, simply because something has not been done before does not necessarily mean that it cannot be done. It's simply a consideration that this body should take into account when it is making its decisions. There is the possibility that someone could try to raise an equal protection claim. It's not clear whether the courts would hear that claim or indeed how they would rule on it if it were raised.
Thank you. Chief Hoskins?
Well, I would just reiterate an earlier statement that I made, that the power, the voice of the representatives of this body is on final passage. The delegate would not possess that right and so would not be exercising that final authority on the part of a member of Congress. And let's remember, the United States crafted this provision and said that the Cherokee Nation shall have a delegate. That's the Cherokee Nation's governmental interest. The Cherokee Nation has read that, and that informed our decision as Cherokee people to fashion our Constitution to appoint the delegate to represent the Cherokee Nation's government. I think that the United States would need to err on the side of making this provision effective rather than, I don't want to suggest finding a way to make it ineffective, but I would say let's find a way to make it effective. Just looking at the plain terms of the treaty, the Cherokee Nation shall have this right.
Okay. Let me ask one final question, and I'll address it initially to you, Dr. Robertson, but I also would then open it up to the panel. And, you know, in this body, we all have our differences, but we're generally pretty united on we're not very fond of the United States Senate. You know, and there seems to be a bipartisan consensus on that, and it really doesn't matter who happens to be in control at a given moment. We have our problems with the Senate. So we have a treaty that was obviously, concluded by representatives of the President of the United States, approved by the Senate of the United States, but affects the membership of the House of Representatives. And we obviously were not party to that decision. So to proceed, does the House expressly have to act, number one? And number two, or could you go to a court, for instance, and okay, this is a treaty, right, but does the House, number one, have to act? And again, and we've addressed this a little bit, but I want to be very clear about it. Your opinions collectively between the virtue, again, of a statute and a resolution, depending on how we act. And I think you've all addressed this one way or the other, but I think it'd be very helpful to have it very specific. So if I can start, Professor Robertson, with you.
Sure. Well, I think on the latter question, you know, the path of least resistance, especially if it comported with emotional predispositions, might be the best way to go, which is to say, to heck with the Senate. Let's just do this ourselves because we decide that it's the right thing to do, to follow through with obligations that the United States undertook to follow through with ages ago. And by the way, I might add, my mother was a Senate staffer during the whole of my childhood, so I understand institutional
We all
house
have
rivalry
to be ashamed
very
of
well.
in our past.
So your first question, I'm sorry, can you remind me? It was whether you have to act or whether this.
Could this right be enforced in a court without action by the House? In other words, does this require action by the House, be it resolution or statute? And then second, the merits of either one of those approaches.
Yeah, I think my guess is I just taught the political question doctrine cases last week, and my gut is that this is precisely the sort of question that a federal court would decide it did not want to mess with. And so my guess is that this would likely be something that the courts wouldn't want to deal with, although theoretically, I imagine they would have jurisdiction and could. So that's just sort of my guess based on having done this stuff for a long time. As to the merits again of a statute or the House acting unilaterally, I guess I'd repeat what I said earlier. I don't think there's any requirement for a statute. I think that under the terms of the treaty and just the way that courts have dealt with Indian treaties forever, I think this is something you could do on your own. I think that the objective disadvantage is, again, the one that's been alluded to earlier, which is that it would be a terminal right in the sense, or a renewable right. But that's a cost that would be paid by the Cherokee Nation, and it sounds as though they're more than willing to pay it. And so it just seems to me, again, circling back to the beginning, my answer, that it would be easier for you guys to do this on your own. If you believe that it's the right thing to do, and I believe it's the right thing to do, then I'd say go ahead and do it. And then, see how it works out, see if there are challenges. I'm not sure that there would be challenges. I agree with CRS that courts would find justiciable, or that they wanted to involve themselves with. And then in 2 years, see where everybody was and renew it, or maybe at that time pursue a statute.
Okay. Ms. Schwartz?
Thank you. So to the first part of your question, does the House have to act? I think the best answer is yes. I think it would raise serious constitutional questions if the Senate and the President, acting through a treaty, could bind the House to take an action that so inherently affected the internal workings of the House. That would be unprecedented. It would be very different from any other operation of treaties that I'm aware of. To the second part, could this be enforced in court if the House did not act? I again think the best answer is no. And again, we don't have case law directly on this, so the answer is not certain. But there's two things that I think are problematic there. First, it's really unclear who would have the ability to bring that suit to try to enforce it, and whether they would have standing. Secondly, as my co-panelist alluded to, it may present a political question that the courts would not want to engage with under sort of principles of comity. And thirdly, I think if they did address it, that the separation of powers principles would really come into play, that they would be unlikely to order the House to do something that, again, so intricately affects the internal workings of the House on the authority of something that the House had no say in.
Thank you very much. Chief Hoskins?
Congressman, as to the question of the courts, I'll probably think a bit more on the answer before giving this body a final one, in part because I'm going to think about what my fellow panelists have said, in part because the Cherokee Nation has spent quite a bit of time across the street in a lot of cases lately, and maybe we've had our full of the judiciary. But in any case, I think that that this body, as to the second question, this body absolutely could take action, should take action, and I think that from the perspective of the Cherokee Nation, and I don't mean to be overly dramatic, but we have waited 2 centuries. We believe the Senate has acted. We believe the President has acted. And now we think the House acting, even though it is not a durable instrument, that a resolution should pass this body. And I think it would send a powerful message to the country for the United States to keep its promise in that fashion.
Thank you very much. Thank all of you again for appearing. And again, Mr. Chairman, thank you very, very much for holding this hearing. I'm very, very appreciative. Yield back.